A fair and impartial procedure must be adopted. For instance, Canada's 2021 model stipulates that an investor shall approach the tax authorities of both nations, claiming that a tax measure violates the agreement. If the contracting nations are unable to jointly determine that the tax measure does not violate the agreement within 180 days of the investor approaching them, the investor may submit the claim to arbitration. A similar procedure is charted out in the Slovakian model of 2019. On enforcement of awards, India has made a commercial reservation to Article 1 of the New York Convention, like Akshara mentioned, which is why Indian courts refuse to enforce investment arbitration awards. Even though the revised model of India deems an award made in respect of a claim brought under the treaty to have arisen out of a commercial relationship or transaction for purposes of Article 1 of the New York Convention, the Arbitration and Conciliation Act considers it to be a commercial and does not on arbitration to be commercial under the Indian law. To resolve the lack of clarity in this aspect, sufficient changes in domestic law are recommended, including awards arising out of investment arbitration being included within the ambit of foreign awards under Section 44 of the Arbitration and Conciliation Act. On dispute resolution under India's model, India's revised model BIPA refers to the ICSID Convention in articles on submission of claims to arbitration, consent to arbitration, and appointment of arbitrators. Since the precondition for submission of claims to arbitration is that both contracting parties must be signatories to the ICSID Convention, India must clarify its position on the convention. Looking forward, India must also consider evaluating the pros and cons of multilateral investment courts that boast of tenured judges, instead of the current practice of constituting ad hoc tribunals, which are opaque and have led to inconsistent decisions and multiplicity of proceedings. This is extremely relevant as the EU, in other words, India's second largest trading partner, proposed setting up of such investment courts in October 2022. It is important that India's BIPAs account for the interest of all stakeholders. Currently, the Indian government involves in-house consultants and legal experts in the drawing up of model BIPAs. However, other stakeholders, such as Indian investors that are impacted by such agreements, must also be consulted. Lastly, old generation BIPAs are not just a problem for India or developing countries for that matter. Several EU nations have also terminated their BIPAs. Nations might tailor their BIPAs to suit their policy priorities, but they must consider establishing a common platform to facilitate dialogue and reach a uniform BIPA regime across the globe. This will reduce inordinate delays involved in one-to-one negotiations and systematically account for the concerns of developing nations. Lessons can be drawn from discussions on OECD's multilateral agreement on investments and the multilateral platform at the UNCTAD. I would now like to call upon Mr. Mukesh Putani. Mr. Mukesh Putani is the founding partner of BMR Legal. He is an expert in international taxation and transfer pricing. So can you please come and take over?
Thank you, Isha. Good afternoon and a warm welcome to all of you. As you could see, the hard work, people who did all the hard work, their presentation is over, but the people who didn't do much work, they are going to steal the limelight. It's a privilege and honor for the firm to support this important research project. All of you on your table have a barcode. If you just flash the barcode, you will be able to access the report much before we formally launch it. If you need a printed copy, then you need to write to either Vidhi or to BMR Legal, and we will be happy to send it across to you. We are indeed privileged and delighted to host this distinguished panel today. We are still waiting for Justice Sikri, but let me take the liberty to introduce him. He doesn't need any introduction. A former judge of the Supreme Court of India. Justice Sikri was elevated to the Supreme Court in 2013 before serving as the Chief Justice of Punjab and Haryana High Court and the acting Chief Justice of Delhi High Court. He's currently a judge at the Singapore International Commercial Court, a division of Singapore High Court, and part of Singapore Court of Singapore. So my colleagues requested me to say something personal. You can't talk something personal about judges. All I can say is that now he's a neighbor at Panchsheel Park. Our next panelist, as I mentioned the name, please join, is Mr. Balbir Singh, the Additional Solicitor General at the Supreme Court of India. Balbir is amongst the youngest lawyers, welcome Balbir, to be designated as a senior advocate by the Delhi High Court. He was also standing counsel for the Income Tax Department and the Competition Commission of India. What do I say personal about Balbir? I can take the liberty to call him by his first name because he is a former colleague. So welcome Balbir. Please join us. Our third eminent speaker is our panel member, Mr. Balasubramaniam K. He's a Joint Secretary at the Tax Policy Research Unit at the Ministry of Finance. As part of the Tax Policy Research Unit, Mr. Balasubramanian is also involved in government's key policy decisions related to taxation issues. He is not a career civil servant, and since he's a former client, I can take the liberty to call him as Bala. Bala, please welcome. Bala was head of tax until about a few years back of one of the leading IT companies in India. Thank you very much, Bala. Next, we have Ms. Anuradha Dutt. She is the co-founder and managing partner at DMD Advocates, also my inspiration and also the inspiration for this project. She is a seasoned lawyer with close to 4 decades of experience in representing clients on significant litigation and arbitration. She has extensively practiced in international arbitrations related to bilateral investment treaty and is very well known for being part of the Vodafone and Kane arbitration process, a matter which we will discuss later today in the evening. What do I say personally about Ms. Dutt? Only thing common is that she made it to the Indian cricket team, national team. I failed. So welcome, Anu. Join us for the panel.
I can just add that she is possibly responsible for this gathering today in one way or the other.
That's, I put it in a different way. That's the inspiration. I'm also glad to welcome Professor Dr. Prabhash Ranjan, who's a professor and vice dean at the Jindal Global Law School. Mr. Ranjan teaches and publishes on issues related to international tax law and international investment law. He was also a member of the team that drafted the 260th report of the Law Commission on the 2015 draft Model India Bilateral Investment Treaty. Recently, he was invited by the Parliamentary Committee on External Affairs to depose as an expert witness on India and bilateral investment treaties. Welcome, Professor Ranjan. So, thank you all for joining. I look forward to a fascinating discussion. We will start our deliberations in the interest of time because we have about 350 YouTube viewers. And Justice Sikri also gave us the permission to start. He should be coming in at any point in time. So without much ado, let me just occupy my chair and we start with the deliberations. So I just hope you do get a copy by scanning the barcode on your this thing. What we have agreed is in the next 45 minutes a set of questions which are either arising from the report that we have or it is arising from the deliberations that we had with the panel members. Well, all of us are aware that up until the time Vodafone and Kane Hague Arbitral Awards were announced, there was very limited discussion on this topic. We all know the background and the retrospectivity of 2012. We also know the amendment that followed that and what the Hague Tribunal said. Just for everyone's benefit, the Hague Tribunal held in favor of the investors, saying that under the fair and equitable standards of the BIPA, which is the India-Netherlands BIPA for Vodafone and India-UK BIPA for Kane, it provided some very useful observations. So just to set the context for our first theme, I'm going to read out for everyone's benefit. The Hague Tribunal in Kane's case observed that the violation of any one or more of the core principles of fair and equitable standard may breach the fair and equitable standard. And it used some very important terms. It said that if the conduct of the state is arbitrary, unreasonable, discriminatory, involves a lack of due process or denial of justice, or is otherwise grossly unfair or unjust. Further, with regard to the conduct, it said that if such conduct undermines the principle of reasonable stability or predictability and is in violation of investors' legitimate expectations. There's a whole lot of debate on what is legitimate expectations, because that was the view that was put forward by the Union of India. The tribunal further went and expounded on many other terms. It said that certain retrospective regulations could be defensible in the presence of a compelling public policy. Here the public policy of the nation being avoidance of taxation. And then it talked about the principle of proportionality. The tribunal found that the retrospective amendment is not clarificatory in nature, as it had caused a substantial change in the law. Further, the amendment did not have a specific purpose, public purpose, that would justify the legal uncertainty created by it. Let me start with the first theme. What would be the effect of such high standards on fair and equitable standard, and particularly on principle of proportionality, Ms. Dutt, on a sovereign's powers, whether this will lead to what we call it as a regulatory chill amongst investors? And we are for the time being focused on, since you experienced it all in Vodafone and Kane case, we are not considering what happened in 2015 by way of the new model BIT. I'm reading the BITs with UK and Netherlands as they were at the time when you were before the Hague Tribunal.
So firstly, I'm a little surprised at your use of expression chilling effect. Now, I think what we forget is that, yes, tax is a very significant sovereign function. But the BITs, or the BIPA as you call them, are also signed by the same sovereign. So they have laid down, by entering into a treaty, what they expect and what they want to give to a foreign investor. Now, in Vodafone case in Supreme Court, the court clearly held that there was no tax measure as of the date of the transaction, and in fact said if you want to tax such transactions, there should be a law, a prospective. The government comes and, has a retrospective for 30, 40 years. Then you have Damodar Committee, you have Shom Committee set up by the government, which says, no, this is not clarificatory, these are new taxes. And in fact, if you've read, Kane is a public award. And in Kane, the argument of the government of India was that Supreme Court was wrong. So you yourself were actually bringing down the Supreme Court, judgment because it suited you. So I'm not sure use of expression of chilling effect is right. Kane and Vodafone saw, the reaction of the Damodar Committee, then the Shom Committee, what government did, and they said there has to be a balance between the public purpose of a tax and what is being done to, the investor, his interest. And they said in this particular case, they found that the public purpose was far inferior to the retrospectivity that you were bringing it in. And I think I may not be wrong that there was hardly anybody I spoke to in India, except, of course, the government and the bureaucracy, who said that this retrospective amendment was right. And in fact, in 2014, Mr. Arun Jaitley, late Arun Jaitley, himself said this was wrong. So government said this was wrong. It's a legacy issue. We will not do it again. So, you know, it's not really what these tribunals held, but your own policy and your own government and your own people, what they felt about, you know, what was happening. And as I said, bilateral investment treaty is actually also signed by you. So you decide the contours of what you want, what are the rights you want to give to an investor.
Thank you. Ms. Tat, I just, before I hand it over to Bala and Balbir to respond from the government side, I just wanted to also try and see if you can explain the subtle difference that the Hague Tribunal drew between tax dispute and a tax-related investment dispute. And it held it on the latter based on the threshold of the FET standard. And I'll just read out for everyone's benefit. Para 793 said, in a tax dispute, the question is whether and how a particular transaction is taxable under the applicable municipal law or possibly laws of several countries if the transaction is international. In a tax-related investment disputes, on the other hand, the tribunal is tasked with determining whether the respondent state has breached substantive standards of treatment under the investment treaty through the exercise of its authority in the field of taxation and whether liability arises as a result. Would you like to explain to all of us?
So I have not written the judgment, but I will try and explain it.
Yeah.
So CARE happened under India, UK, and Vodafone happened under India, Netherlands. Neither of them had tax as a carve-out. So you have to understand that there were certain arguments addressed in both these arbitrations relating to tax measures, saying that Indian law does not allow tax measure to be arbitrable. So that's where it started. Now, the point is, if it was just to say that this is a tax measure, it's wrong, it's, it's not arbitrable, therefore the tribunal has no power is one thing. But what the tribunal is trying to say is that a tax measure which has a chilling effect, if I can use your words, on the investor's investment, then definitely the tribunal has the jurisdiction to decide on this issue.
My reason to bring out this subtle difference between tax dispute and tax-related dispute in an investment dispute is because this goes to the core of the research, which is what do we mean by saying a tax measure? Whether the right to tax must be considered a absolute sovereign right and not being subjected to investment treaties, because that is what the 2015 model dictates. I don't know, Balbir and Bala, if you'd like to come at this point in time and explain, because the 2015 model looks at tax measure in a different way than the Hague Tribunal has looked at it.
I think since Anu has experienced this more than anybody else, and we are at a point where we have these two awards in place, and there is a lot of learning from that. What I personally see is that over a period of any agreement which was signed in 1990, I'm not sure people realize the world is flat. And if we go back to 2005, the book written by the Thomas Friedman, he will also not believe that the world is flat anymore. So certainly the walls have come up and the world has gone more protectionist, whether these treaties fit in today's time or not. And I'm sure that's why not only in India, the multiple countries are looking at in renegotiating treaties or cancelling treaties. I think that's as a walk of time, the way the capital and the human resources have started moving globally. People have, over a period of time, getting more protectionist. That's a larger comment. Coming to specific issue of tax being per se a arbitrable dispute or not, and it's a sovereign function, I don't think there is too much of a debate on this part. Every sovereign nation is responsible for running a country, and tax being a very serious component of it, and the parliament can make law on tax. I don't think there is going to be any issue on this part. It is arbitrable or not, looking at the treaties which were signed in 1990, I don't think even in Kane and Vodafone it has gone to the extent of saying that the tax per se is a arbitrable dispute, and the government can't impose any tax on any particular thing. If you look at a cause and effect theory, which is, you are saying, a tax dispute or a tax related investment dispute, if a tax is resulting into any dispute which is impairing the investment which has come into India, and we're looking at the terms of these treaty, I think the fundamental principles, if we look from the FET point of view also, we need to see it from two buckets. One is where nobody denies that it should be fair, it should be transparent, and it should not be malafide, for sure. And as I understand, and Anu can clarify this part, that in Kane Energy, the tribunal has gone to the extent of saying the retrospective amendment has been a malafide attempt. That's what I presume, that's the wording which has been used in this. So far as this bucket is concerned, I completely agree that when two parties enter into any contract, and why a sovereign should have a different fundamental basis to interpret the treaty, there should be fairness. So far as the other bucket which is concerned, which is the legitimate expectation if we talk of, or if we talk of the predictability, I think these are the areas which certainly, if two countries want to sit down and want to renegotiate it, those areas should be renegotiated, because legitimate expectation is a very subjective, can depend on a case-to-case law, whether the sovereign wants to get into that debate and that option to be given to the tribunal to interpret or not. I think that right should be there between the two parties. But so far as the fairness, the transparency, malafide, public interest, I don't think it would be fair on anybody's part, including a sovereign nation, to say that even if the foreign investment has been impaired by virtue of a consequence of a tax, as I said, a cause and effect, if the effect is resulting into it, I think I agree on that part which should be there.
Please. Sir, I've taken the liberty to introduce you, but we didn't wanted to perform the solemn function of opening the book. So as soon as Balbir completes this point, then we will inaugurate.
That's what my preliminary observation is on this.
So may I invite all my co-panelists and guests of honor to just give a peek view of the book to all of you.
Congratulations to Vidhi and I think BMR. What a great effort you guys have put in this.
Thank you. Thanks, Balbir, for making that point. Bala, would you like to come in before we hand it over to Professor Ranjan for his comments, because he is widely written on both the awards?
In fact, I have a very precarious situation because I can't, wear my earlier hat of a private sector, and I have a very, arduous role to perform here as representing the government of India. But my views are, are personal, so it doesn't represent the views of the government of India. So let me make that disclaimer, first. But I think, we need to step back. I think the Vodafone cane is behind us, right? Now to browbeat on the retrospective amendment and what happened, in the arbitration, I think we have to move away from it. We have to look at what is on the table today, right? We have a model BIT which is before us. There is a carve-out which is there, and that is a stated position of the government that we are not open to, at this point in time, we are not mature enough to look at tax as an arbitrable item, where we open it up for a foreign authority to look at it and make certain observations on the tax measures, which is at sovereign function, right? So, let us look back at where the right to tax come from, right? The Article 265 gives us the authority to tax. So if I can't tax somebody without an authority to tax, how do I give a relief or give effect to an arbitration without that authority to tax, right? So let us look back, step back and see that how I would have given effect to the arbitration award. Without what we did in 2021, we had to bring out, an amendment in law, right? Without that, I couldn't have given. If I had to give, we would have given it as a normal compensation. It wouldn't have been a tax refund, right? So from that perspective, we have to look at it as a sovereign function. At this point in time, we don't want to open up tax for an arbitration at this. That is number one. Number two, even if we look at the double tax avoidance agreements, right? Even there, the stated position of the government is we will not accept arbitration. So rightly or wrongly, even in the multilateral agreements, we have not agreed for arbitration. We don't even want a mediation, in certain domestic, tax disputes, right? So therefore, I would say that this, in fact, the report has come out at the right time. This is a start of a process. We need to engage with the administration to see how we can mature to get to, a mediation, to an arbitration, start step by step and then open it up. So I would say that, this report is a good initial start to initiate that discussion even within the government.
Thank you, Bala. And the report is indeed forward-looking. Our objective was not to beat Kane and Vodafone Hague Tribunal Awards in this report at all. In fact, there's hardly any mention. The report is all about what does 2015 BIT model talk in terms of tax carve-outs and what does that hold. Professor Ranjan, I just wanted your quick view, but since Bala mentioned about double tax treaties and India doesn't have arbitration in the double tax treaties, in fact, the union did take up this argument before the Hague Tribunal, and this is what para 803 of the Kane Tribunal said. It says the former, which is a tax treaty, provides rules for the avoidance of double taxation and prevention of fiscal evasion with respect to taxes on income and capital applicable to residents of each contracting state. While the latter, which is the BIPA, each contracting state agrees to treat the investment in its territory made by nationals of the other contracting party in accordance with certain standards of treatment. This is the FET standard. So the Hague Tribunal negated the theory that all disputes have to be resolved within the framework of the double tax treaty, and we need to look at the investment standards as well. So in light of all the observations made by our panelists and this observation which I made in reaction to what Bala mentioned, your observations.
Yeah, thank you very much for this opportunity. I want to make few specific points about the Kane Energy Award. I think the perception is that since India lost the claim, or since states have lost several claims on taxation, therefore there's this theory of regulatory chill that you referred to and Ms. Dutt also referred to. There is some merit behind the theory of regulatory chill, but this does not mean that each time an investor brings a claim against the state, it has a chilling effect on the state's right to regulate. In fact, if you read the Kane Award minutely, you will find that the Kane Tribunal has actually given ample regulatory space to the state. Before the Kane Energy Award, the perception or the understanding amongst international investment law scholars was that the moment a country changes any law, not just taxation, any law retroactively, that on its own would be a breach of the investor's legitimate expectations. But the Kane Energy Tribunal brought in a nuanced understanding to this, and it said that simply because the law has been changed retroactively, that on its own does not violate the treaty provision. right? And this is a very important clarification that the tribunal has brought. So which means that India could have, hypothetically speaking, India could have imposed the law retroactively had it imposed the tax in a proportionate manner. So I guess it's the test of proportionality which matters here. And as Ms. Dutt mentioned, that if you take back the retroactive amendment to 1961, for a alleged tax abuse or tax evasion that is taking place in 90s or 2000, then that clearly is a disproportionate burden being imposed on the investor. So in other words, there is ample space available to states to enact regulatory measures, including taxation, as long as they do not impose a disproportionate burden on the investor. To answer your specific question on the relationship between the double taxation avoidance agreements and investment treaties, when a dispute is brought before an arbitration tribunal constituted under the investment treaty, the arbitration tribunal is bound to look at the investment treaty, and any other instrument would only be a secondary instrument under international law. So under international law, every tribunal or every court or every judge will have to apply the rules of treaty interpretation contained in the Vienna Convention on Law of Treaties. And under the Vienna Convention on Law of Treaties, any other rule can only be an applicable rule under Article 31(3)(c) of the VCLT. So it can only be brought into the equation. Then the tribunal will have to accord adequate weightage to it and then decide to what extent it will influence the interpretation of the existing investment treaty or not. Plus, as you mentioned, there are other sort of tools to settle the norm conflicts in terms of lex specialis, lex posterior, and that is precisely what the tribunal did in this case. So sort of to summarize my point, what I want to say is that states are touchy about taxation, and rightly so, because taxation is recognized as part of states' police powers. But it is not that the ISDS tribunals are not deferential toward the state on taxation measures. ISDS tribunals are deferential to the state on taxation measures. It's just that when the taxation measure crosses a certain boundary, crosses a certain line, it is then that the ISDS tribunal steps in and holds the state accountable for its treaty breach.
Let's now move on from the Kane and arbitral award, and let's imagine a hypothetical situation that if Kane and a Vodafone situation arises in 2023, wherein the new model will apply. That's also a hypothetical situation because India does not have any signed investment treaties either with Netherlands or with the UK. But let's assume that. So if I look at the 2015 model, it has excluded tax measures from its very scope. My research colleagues spoke about general carve-out, specific carve-out. There are 6 kinds of carve-outs between general and specific carve-out. This falls in the general category. It says, India's BIPA model says that the host state will now have the authority to determine what constitutes a tax measure. It will make such determination even subsequent to the commencement of the arbitration proceedings. It doesn't stop there. It says further, such determination is not justiciable and not open to any arbitration tribunal to review. Now, if I look at these 3 clauses in the 2015 model, and I compare it to a general carve-out under the India-Canada, so it's one thing to say, India is not the only country that has terminated BIPA. India is not the only country that has got general carve-out. Even Canada has it. But the Canadian carve-out, which is the Canadian model of 2021, has some very interesting checks and balances. It contains procedures, it contains timelines that need to be followed when determining a tax measure by the competent authorities, something that Isha spoke about. So I'm not going to get into that, but these are now the 2 models, and we have devoted 1 chapter specifically to compare the general carve-out. Now the question is, does India's broad carve-out lack procedure which will impact certainty under BIPA? Anu, would you like to take that? What if you were doing Vodafone and case in 2023?
So I forget Vodafone.
Yeah.
The fact that only 2 countries have signed and it's in force itself shows that other countries are not buying it. But you know, for my limited knowledge of bilateral investment treaties show that even where there are general carve-outs, there are still cases pending because expropriation is is one field where if the tax measure goes to the extent, if a state, wants to expropriate an investment through tax measures, I'm sure the tribunals will find a way out of that. But yes, as one of your colleagues had earlier said, there are, like Encana case, there was a carve out of tax measure, and they held that no, even though VAT refunds were to be given, and they changed the law, they didn't. In Occidental case, which is a US company, there the treaty said you must be fair. So the tribunal said, okay, you must be fair, and similar circumstances where VAT refunds were not given, they held that this is unfair and gave relief. So it really depends on facts of a case. To my mind, Vodafone and K, not because I handled Vodafone, but I think as a citizen of India, I would like to see, forget Vodafone and Kane. Do I as a citizen like it that you give me retrospective amendments time and again? I don't, because I think legal certainty and rule of law should be similar for even Indian citizens and not just foreign investors. So, the fact that nobody is buying your treaty, as I started with, is also an indicia that people are not, the countries are not really buying into what you are wanting them to. And secondly, today we see a lot of outflow of Indian capital. Now, the countries that you have signed with are more likely, except maybe Taiwan, where Indian capital will flow. And to have, these kind of measures or these boundaries for your own capital, I think needs a relook.
So I'll just get both Balbir and Bala to respond in their personal capacity. The framework of the 2015 model is Article 2, which says scope and general provisions, treaty shall apply to. And then it says sub-article 2, treaty shall not apply to. And your general tax carve-out is in those 6 categories. Then chapter 3 deals with obligations of parties, which means treatment of investment. It says no party shall be subjected to investments made by investors to measures which constitute a violation of customary international law. So if India fails in their obligation and violates a customary international law, then the BIT treaty should apply even under the 2015 model. But what I am told by my research colleagues is that this obligation will stand overridden because the scope is restricted. Now, in light of the comment that Ms. Dutt made, I just also wanted to find out that there are many experiences on general carve-outs with many countries. So there is a very famous case called the Renta case, in which tribunal was dealing with a general carve-out. The state lost this case. Soviet Union lost this case under BIPA, and the tribunal in that case had to make a very interesting observation. So there was a carve-out, just like we see in the 2015 model. It says that state cannot take a defense of a general tax carve-out if the tax measure was imposed without a bona fide intent, and I mean public policy. Therefore, such a general carve-out does not ensure a complete immunity to the state. And the question that arises is that, is this now a credible solution for India going forward, or will we see more such disputes, Renta case arising against India in these situations? So I don't know if you'd like to respond to that.
See, I think first of all, if we look at the structure of this model treaty, as Anuradha said, the first challenge is whether anybody is going to sign this treaty in the current shape and form. But presuming that somebody has signed this treaty in the current shape and form, and looking at the definition of tax carve-out in it, and if I correctly recall, the tax carve-out is not simply a tax here, but the impact of tax on the investment is also, that's the wording and the language of the treaty is coming out. So therefore, some attempt has been made to see that not only the cause but the effect also is taken care of as a carve out. The challenge is that why two parties get into a treaty of this nature, because the protection of investment is to be seen. So the very fundamental of any treaty is that any impairment of investment is to be protected. And if you see the scope of protection maybe based on the international customary law, there is going to be a challenge for sure that if we have seen, including if we look at the Renta case also, the threshold is certainly going to be much higher. Today there is a carve out which has been specifically provided for. Tax is a sovereign power which has been given to a parliament, and the taxes can be imposed. But having said that, the very essence of a treaty which has been entered into between two sovereign nations and international customary law is the window which has been given in clause 3, I believe, which has been given. I still see in certain cases, although as I said, the threshold is going to be certainly much higher, as said that if it is the public policy issue against the public interest, or the state is unable to satisfy the bona fide, in those events I certainly see, and based on the past experience, that yes, the tribunal can still come after in those cases. But the general understanding of the tax carve-out which has been structured, and on the presumption that two parties have entered into this kind of a contract, this gives a much larger and a stronger protection than what we see in the treaty which was there in the earlier round.
Yeah, I think very rightly said by the law officer of the government. So only thing that I would like to add is, to what he said, to the legal points that he mentioned, is taking from where he said about the threshold part, right? The threshold is going to be high. The only hope from the tax policy side is that we will not repeat what we did in 2012, right? So we have set out a path saying that we will not do retrospective amendments, and that's a commitment made in the House of the Parliament, and that would be respected going forward as well. So having said that, if something extraordinarily happens, it would still be open for the tribunal to look at it, and at that time, we'll have to look at whether the treaty language that is there would protect us or not protect us. But to point out what Ms. Dutt said on the number of treaties that we are actively, in negotiation with many countries, and we hope that it would be resolved in the next few years. So it's not that we have not, there's been a chill from the other side. So it's a very active engagement we have with a lot of countries. The focus now is on the FTAs rather than on BIPA. So there is some kind of a shift in the policy that has happened. But even on BIPAs, I think we have got tremendous encouragement from the other side of the countries.
Professor Ranjan, having deposed before the Parliamentary Committee and Law Commission as well, I just wanted to draw another context to the 2015 model. So the biggest difference is, besides the tax carve-out, complete omission of fair and equitable treatment. And in place of fair and equitable treatment is 4 forms of issues where BIPA would be considered. Denial of justice in any judicial proceedings, fundamental breach of due process, targeted discrimination or manifestly unjustified grounds such as gender, race, religion, manifestly abusive treatment such as coercion, duress and harassment. All of these 4 principles now have to be read in accordance with customary international law. Do you think this affords an element of protection and is a credible substitution for the FET standard? Because there is no FET standard now under the 2015 model.
Yeah, before I answer that question, if I can just quickly reflect on the point about the taxation carve-out and the high threshold that Mr. Singh and Bala also talked about. I think it's important for us to keep in mind, as I mentioned, that let's assume you have signed an investment treaty which does not contain any tax carve-out, and the state imposes, or let's assume India had changed the same law, section 9(1) sub clause 1, prospectively, and you still had foreign investors going to arbitration tribunals. I'm pretty sure the arbitration tribunals would have ruled in favor of India, because they would have still given a high threshold, even if there is no complete carve-out for taxation measures in the India-UK or the India-Netherlands PIT. So the presence of carve-out does not on its own guarantee success. In the Renta or the UCOS case, as you are pointing out, it came under the Energy Charter Treaty, which contains a complete carve-out for taxation measures. But because Russia imposed this taxation measure deliberately to harm one particular foreign investor, therefore the arbitration ruled that this, we still have jurisdiction and we can still hold you guilty for breaching the treaty. So my point is that even if you don't have a carve-out, as long as you impose a reasonable bona fide, general taxation measure, it will not amount to, or it will not trigger a BIT sort of, a BIT breach. On the exclusion of FET, this is very interesting. So it's not just the FET part. Indian model BIT does not even contain the MFN provision. And this is a direct white industries outcome. So we lost the white industries case because of the MFN, and therefore we thought the solution is not to have the MFN provision at all, which in my view is not the correct solution. And we had pointed this out in the Law Commission report on the draft model BIT, where we had proposed to have a nuanced MFN provision rather than doing away with the MFN provision completely. But the final model that we got still doesn't have the MFN provision. The absence of FET, again, the same story. In fact, I would say that India has complicated matters further by bringing in the notion of customary international law, including all these four heads which you mentioned. Because one of the problems with the ISDS case law has been that the arbitration tribunals have interpreted customary international law in a very broad fashion to include several elements into the domain of customary international law. Therefore, the solution to this is what European Union and Canada have done in the EU-Canada CETA in the investment chapter. They have actually defined what should be the meaning of fair and equitable treatment provision. And they do not make any reference to customary international law, because the moment you make reference to customary international law, you bring in the entire historical baggage of what it means, state practice, opinio juris, so on and so forth. So therefore, that in my view should have been the correct approach that India should follow. And finally, on the point of negotiations and why only 2 countries have bought what we are selling, my theory is slightly different, maybe a little controversial, but allow me to say it. I argued this in my piece in the Indian Express a few days back. I think that we are not even aggressively selling the bad product that we have. Yes, I agree we are focusing on the FTA negotiations, but as I argued in my piece, if you look at India's recent FTAs, unlike India's old FTAs, they do not contain an investment chapter. And we have unilaterally terminated our investment treaty with Australia. We have an FTA, but without an investment chapter. We have terminated our BIT with Mauritius. We have an FTA, but again, without an investment chapter. The real test is what are we going to do with UK and EU, because we are negotiating FTA and they are very keen to have an investment chapter. So my own theory is that India is perhaps following an approach which scholars call as the domestication and delegalization of international investment law, where they are saying that foreign investors should be happy with our domestic laws and we will not give them commitments under international law as regards their protection is concerned.
I have an update on the EU trade policy, because I just managed to pull out one of the Brussels press release on what they feel about India. But before that, let me just lay down a context to what our researchers were talking about. And there's a particular chapter devoted in our research report, which is EU proposing a multilateral investment code. So just for everyone's knowledge, inter se within the EU, all BITs were terminated, and they were terminated because they felt that this goes against the strict standards of the EU Charter and Convention. But instead, they have proposed a multilateral investment code, and Isha spoke about what are the features of the code, but I'll just mention one line. The multilateral investment code essentially replaces bilateral investment code system, and which is now included in the EU trade and investment agreements. It's clearly a major departure from the system of investor to state dispute resolution, because historically the dispute resolution under bids were between investor and the states. So we will need to see how it comes out. Now on EU, interestingly, the last press release, and maybe we can start with Bala, on where India stands on the first round of trade negotiation, trade and investment negotiation. So unlike the Mauritius example and the Australia example that Professor Ranjan gave, the EU is trade and an investment agreement. The last press release of Government of India spoke about second round of negotiations will take place in September 22. Well, it took place in October 11, 12 and 14/2022. Interestingly, the press release by the EU Commission said the second round of EU-India Investment Protection Agreement negotiation took place virtually. So this is investment protection agreement. They're not even talking about trade. Discussions revolve around the EU proposal for an investment court system and other provisions on dispute resolution in EU's text proposal and India's text proposal on investment protection. The press release stops over there and says the third round of negotiations will take place in December. I couldn't find any update, at least in the public record, on what happened in December 2022. Now, to me, it seems that somewhere India is reconsidering its stance. Somewhere India is revisiting. I don't know the nuances with that, but the fact that the EU went ahead and issued this press release talking about investment court system could have been unilateral, but it could have been some sense of negotiation that India is a part of. Bala, we don't want you to reveal any or be hauled up under the Official Secrets Act.
No,
but
so no, I can't reveal too much than what is there on the press release. But I think you must not attach too much importance to the titles there, because these titles are the meeting names that are agreed to, right? I agree with you that the press release from the EU talked about investment court. Yes, that is in the public domain in terms of what is their multilateral investment court all about. So there are possibly discussions happening on both sides. But at this stage, I think it is very premature to make any statement on behalf of the government on that.
Sure. No, thank you, Bala, and we completely appreciate your situation. Ms. Dutt, I just wanted to come to you. What does this mean for India? Assuming my assumption is right, could these EU recommendations be actually a credible investment arbitration forum for lawyers such as yourself? What do you think about it, assuming it becomes a reality?
See, to my mind, it's what they're trying to do is give a structure, because today it's ad hoc. Now, ad hoc also, these people who we appoint are lawyers or retired judges who are extremely distinguished. But if you want to give a structure, have permanent, like a permanent court of arbitration, etc., there's nothing wrong in it. But I think we are very far away. It's still a long way to reach. We don't know where, there are still negotiations, so I'm not sure. But I have no problem if India or whoever wants to join a structured, well, they didn't join ICSID, so I'm not sure whether what they will do.
It's a very interesting experience, and I think Justice Sikri can confirm. Justice Sundaresh Menon, the Chief Justice of Singapore High Court, Singapore Supreme Court. So he tried to create a Asian commercial court, and this was taken to multiple countries, and I understand that a few of Supreme Court judges also participated in some conferences way back, that can we write off jurisdiction of Indian courts in certain types of dispute, and it can be given to a court which can be created in Singapore like SIAC, parallel to a commercial court there. But it didn't work out in my understanding, but there was quite an effort which was made a couple of years back on this, and he took a great interest in a lot of Southeast Asian countries agreed, they were willing to give their jurisdiction to that particular court and a particular nature of but it never fructified to a point where it became a reality.
So I think ultimately a nation has to decide, has to balance its requirement for foreign direct investment and what am I going to give away for attracting that investment. So it's a competing interest which a nation has to really decide what it wants to do. How far will it go?
Correct. I think
Just to, the query which you have raised about this Justice Sundaresh Menon's efforts, actually it was in two directions when you talked about this Asian. He set up, it was maybe in 2014 or 15,
yes,
because this is called ABLI, Asian Business Law Association, where his aim or endeavor was to have convergence of laws. That is at least because, when we talk of globalization and we talk of, here we are talking about FDI, and in the FDI, of course, you are discussing only one aspect, that is the tax. But in ICSID, there are so many, when the arbitration takes place, the disputes may have so many other dimensions and other complexities as well. But then one thing which is the result of globalization, now I'm saying generally, making a statement, is that there is an attempt of convergence of laws. There should be uniformity of laws. UNCITRAL has been working on that. And if I give simple example, arbitration acts, which have all changed, because they are now, because of globalization, the disputes which are now coming up have international flavors, cross-border ramifications. So therefore, the attempt is that there should not be, domestic laws should not be at divergence from each other radically. So that, and that's why this UNCITRAL came out with model arbitration law and requested all the countries, and I think almost 200 countries today have accepted that. And we also enacted Arbitration and Conciliation Act 1996. Then I give you the example of, because when collaborations take place, and say know-how, technical know-how, etc. also comes. So they want to, the company, say foreign company, because foreign direct investment is not only in the form of capital investment, but it means technology as well. So they would like to protect their intellectual property rights. And therefore, if you see, the WTO came out with that the laws should be now of most of the countries, should be, there should be convergence and there should be some uniformity. And India came out with new this Trademark Act. There was drastic changes in the Patent Act and the Copyright Act, etc. Also to Competition Act. So there are so many laws as such, and therefore that is one aspect which has to be. So therefore, coming back to now, Justice Sundesh Menon wanted that when we talk of convergence, at least let us start from Asia. If we are not able to achieve at international law level, and some of the commercial laws, particularly the Contract Act and Sale of Goods Act, which is International Sale of Goods Act, is again a very hot topic. So on that, institute was, this ABLE was constituted, and 4 persons who were there, I was one of them, who was taken by Justice Sundesh Menon. It had been working. It came out with some reports on Sale of Goods Act, also insolvency laws as well. And there's few reports came, not that, it may be, institute is still there, it is doing its research, it is producing some good research papers, but yes, when it comes to whether the countries are adopting, and so that second level has not been achieved. That is one aspect. That was only a research institute. Second aspect of what you said about court.
Yes.
The court is there. It has been established in 2015. This is called Singapore International Commercial Court, and I am one of the judges there. So therefore, that court is functioning, and the question is here, of course, it's a totally different thing, and in the context of even investment disputes, today there is a debate that there are so many anomalies which are found, and many nations are not happy, including India, and that is why India snapped all these bilateral investment treaties, particularly after White Industries case. That sometimes what happens is, and let me be very frank and blunt about it, ICSID judges, or those, I will say arbitrators, and then those who have become popular in doing arbitration, in investment arbitration as arbitrators. So they are now falling in 2 categories. That is the perception. Those who are pro-investors and those who are pro-states. So therefore, whenever a dispute arises and a nation has to nominate, they will go for that particular arbitrator who is pro-state, and the entire background of that particular person is seen and judged, and those who are pro-investors, so the investor would go and nominate. And so therefore, there are certain aspects, and there are some cases, 3 or 4 cases, when actually I had prepared also for my note, although these are not relating to tax, but then which have given, at least countries, nations, are suspicious about the approach of ICSID. ICSID has been saying that, look, that is wrong. We are not, our many awards are not, and if you go by the statistics, that we have given more awards which are in favor of the countries or republics. But anyway, that is a debate which is going on. But then coming back to this international court, so it is said that number one, there would be independent judges, of course, from all countries, but not judges who are appointed by. And number two, more importantly, many times insofar as these international disputes and particularly investment treaty disputes are concerned, many times both sides are not very happy with the outcome. But as far as arbitration is concerned, it is final. And they want a second bite on the cherry, which is provided in the court system only, that you have a right to appeal. So that is what debate which is going on. And of course, SICC is working. Today, I don't think, as far as my knowledge goes, any investment treaty case has come to the court. But then there are many other commercial court cases, commercial disputes, which are going to the court. That the people prefer court rather than arbitration. So that is how SICC is functioning.
I think this is one of the criticism when we see the all international BIT arbitrations, because these the tribunals, the way they are functioning, there is a question of a although this is going to be I don't know what is, because I'm not speaking for the government of India in this sense. I'm not aware that what is the mechanism which is created. But yes, if this some court or some authority is there where there is no involvement of two parties appointing, and they are agreeing to this in a particular arrangement, and there is a appellate remedy available, like in the Singapore in the ordinary commercial courts, that will settle the score so far as the criticism of the way the tribunals are functioning. Because that's a very one fundamental factor emerging, that whether tribunals are functioning fine or not.
Thank you. Professor Ranjan, you had a point, and then we will have Justice Sikri sum up the discussions.
Yeah, just very quickly on the investment court. I agree with Justice Sikri and the deficiencies that he has told about the investment arbitration system. And in fact, this is the reason which has prompted EU and other countries to have negotiations under UNCITRAL Working Group 3 to create this multilateral investment court. In fact, I'll sort of raise a more conceptual question. The question is whether arbitration is the correct mechanism to resolve investment treaty disputes. Because arbitration was conceived in a completely different system for a private law, whether it's the correct system to address public law questions of the kind that investment treaty arbitration involves. Now, coming back to the EU point which you mentioned, Mukesh, it's very clear that if India has to have an investment protection agreement with EU, it has to have an investment court. If you look at EU's investment protection agreements with Vietnam, with Singapore, with Canada, all of them have created a bilateral investment court. And they say that this bilateral investment court will be merged into that international investment court if and when it gets created. Correct. So the arrangement is that both the countries should have a panel of 15 judges, sort of tenured judges, who will be judges irrespective of whether a claim is brought or not. And they will function like a court, and there will be an appellate mechanism as well to bring in more consistency and coherence in the case law. But the problem that I see is that, to the best of my knowledge, India doesn't have a clear position on International Investment Court as of now. Although India is participating in the negotiations as an observer, but I have studied very carefully all the negotiating documents and history. I haven't come across any intervention that India has made in these negotiations. So I think it's important for India to come out with a clear position on International Investment Court, whether it is supportive of it or whether it is dismissive of it. That would be good, not just for India, but also for all the ongoing negotiations with EU, UK, etc. Thank you.
Thank you. With that, let me hand it over to Honorable Justice Sikri. Thank you very much, sir, for gracing this occasion. And we started 5 minutes late, so we have time, and then we will take
be as short as possible.
some questions as well.
I think, and that first of all, okay, let me congratulate you for this wonderful review of this tax carve-outs under the bilateral investment protection agreements or treaties. And I could not go through it entirely, but substantially. And it's a wonderful work.
Thank you.
And particularly in today's context, and this panel discussion has proved that point, that it's an idea whose time has come. And when, I mean, both are persons from who are, I can say, government representatives, although they have expressed their views, personal views, and not the views of the government, I can understand that kind of disclaimer. But I feel that it is going to be a very good guide, I would say, or at least it would be of good, it is going to be of good assistance to the policymakers. At least they will think on many aspects which you have highlighted. Of course, apart from the law, at the end when you have given your recommendations and your conclusions, and which I read and are worth, some of that are worth giving serious thoughts at least as to where the country has to go. Let me say that, and that if I sum up from the, of course I missed initial parts of the discussion, but it is entirely, when it comes to particularly tax treaty, but tax aspects of BITs, but generally even under BIPA, it's always a dispute or a rather struggle between the claim of nations to sovereignty on the one hand, and some of the aspects under international law which may impinge upon that kind of sovereignty. But let me start with one thing, one aspect, although I have highlighted already, is that we are in the era of globalization, and we are talking about FDIs. When I mean foreign direct investment comes, of course, and what is the interest of an investor? That investment should remain protected. Of course, every investor, I'm not talking of only foreign investor, even if I'm investing in shares in a company, or I'm even putting my money in a bank account, etc., I want that my investment should be safe, and I want some fairly reasonable return on that investment. So obviously a foreign investor would also like to have that. Second aspect is of globalization was, first, as I said, about convergence, which I mentioned. Second is that when we talk about international disputes, etc., and particularly many arbitration, the way international arbitration is developing, to some extent there is a ceding of sovereignty or sovereign powers. I give you one simple example which everybody will understand. We talk of autonomy of the parties in arbitration disputes, so the parties choose their own arbitrators and constitute their own arbitral tribunal, etc., which go into that. But then there are various different facets and nuances of this party autonomy. And you see how the law has developed in this country. First, let me give you an example of not example, legal position when it comes to court system. We have in CPC, Civil Procedure Code, the provisions relating to which court has the territorial jurisdiction to decide the case. And section 20 very clearly says where either the cause of action or part of cause of action has arisen, or where the defendant resides and works for gain. So therefore, in order to confer jurisdiction on a particular court, we have to come within this. Then in court judgment, you would have found that distinction is made irregularity in the exercise of jurisdiction and inherent lack of jurisdiction. The concept of inherent lack of jurisdiction is that if a court lacks jurisdiction inherently, even the consent of the parties cannot confer jurisdiction. Now test this in arbitration. It's a total change, just diametrically opposite position. Up to now, rather, I mean, it was under that the parties can choose. So in choosing it, you can even have, if there are two parties, one is Indian party and one is foreign party, you can have, and say India and German, you can have that, okay, if there is a dispute, we'll go to third country, say Singapore or London LCIA, and they will decide our dispute. So you are conferring by this consent jurisdiction on a country or on a body, and there, very interesting thing, it's not only jurisdiction, you can, what law would apply, that also you decide. That it is although the parties are Indian and German parties, they say, okay, Singapore law will apply. So this is in that, but this is totally contrary to section 20 where the concept of sovereignty arises. But the Indian Supreme Court has now gone far ahead. Even two Indian parties, what to talk of international, two Indian parties can choose a foreign jurisdiction.
Correct.
So therefore, this, when the law is coming to this extent, there is bound to be some clash. On the one hand, where the sovereign nations have to exercise this, nations have to exercise their sovereign power, and on the other hand, international law, which talks otherwise. But let me tell you one thing. Even international law, and I think Professor Prabhash Ranjan is an authority on that, but what I feel with my limited knowledge and doing a couple of bilateral investment treaty arbitrations which I am doing. So that international law also recognizes the sovereignty of nations. It's not that it doesn't recognize. But then the entire and all these cases with case law which appear to be of exit judgments also, ISID's awards also, where we find under certain circumstances their approach is different by two different tribunals. It may be because of the reason that when under this BIPA, they come out with the provisions, okay, it's not a fair treatment which is given. So these are the escape routes which are found by some of the, and that depends upon, that is why I said pro-investor arbitral tribunal, or it is pro-state arbitral tribunal. So same thing would be looked into from one prism by one set of persons and by other prism, and that is why it gives rise to the situation where at least apparently it appears that there is contradiction in the case. Let me, because I don't have much experience, because the cases which I am doing, though tax issues have not come in those cases. But let me tell you one or two very interesting cases which I wrote one article on these BITs, I think 7, 8 years ago, and I had given these 3 cases. And one case, if I tell you, and these are the cases where there is clear, in a way, impingement upon the sovereignty of a nation. And let me, okay, before coming to that, start with this, as far as tax aspects are concerned. Now, we say, what is the Indian law insofar as arbitrability, which when I came and Mr. Balasubramaniam was mentioning about it, what is the Indian law on arbitrability? Tax matters are not clearly arbitrable. That is the law on the point, and it is stated in the judgments, all Booz Allen to Ayaswamy, and then that Duralia case, etc. It's very clear which are the cases which are to be excluded from arbitrability. So a case which is, whenever there is a tax dispute, it cannot be arbitrated, and therefore it has to be as per the system which is set up by a country. Again, sovereign power which comes, that we have our tax tribunals, and tax tribunals will decide that. And that gives rise to that debate which Prakash also said about it, whether all these cases, there are some countries which feel all these tax matters, etc., should go by the domestic laws of a country. And then suppose it's a tax dispute, whether it's an investment, and in the investment is made in this country, but the tax dispute has arisen here. So you get it resolved through the system which is provided by this country. So this is one view. But on the other hand, when it comes to the enforcement of a treaty, and then these 3-4 things which we have also mentioned in your report. One is that the treatment provision, and it comes to that whether it is discriminatory, etc., or not, and where MFN treatment is to be given, and this white industry case, rather it is a very interesting case where award was in favor of that Australian party against Coal India, I think. Against Coal India. Coal India had challenged, matter was pending before Calcutta High Court, but it had taken 8-10 years.
Supreme Court also.
Supreme Court also, yes, some aspects had gone and which were pending there. So the case was taken before the tribunal on the ground that look, it's a failure of legal system in this country, it is taking so much of time, etc., and therefore it's not a fair treatment to us. This contention was rejected specifically by the court, because it is not unfair treatment in the sense that it's not that because system is because of case law, case load, etc., it takes that much time, but that is a treatment which is given to everybody, and it's not that you are discriminated against. But at the same time, under MFN, the tribunal said that we have the power and we will decide. In spite of the fact that the issue has already been decided, where and matter, of course, now it is Republic of India, there it was Coal India, that's the only difference, because it's a investment treaty. But then what happens, suppose, in a situation like this, ultimately, if the court had set aside the award, the national courts of the country say that this award is not enforceable, or this award suffers from some infirmities. It was ICC award, and it has come for, I'm just saying, hypothetical situation. So on the one hand, this aspect, on the other hand, the arbitral tribunal saying that no, because of this investment treaty, we have the power to go. And I give you now another example, and this is really very interesting example. There's one case, Lowen Group versus United States. And in this case, it's a ICSID award of 2003. Now, what had happened, there was one Canadian-based conglomerate which has having its business activities throughout United States. And one person brought a case in United States in court on say that alleging that this company, this group is indulging in anti-competitive conduct. Court found it to be so, and court imposed rather the compensation it was given to that person, $500 million. He goes in appeal. In the appeal in that particular state, there was a provision that you have to deposit, I think 25% of the amount only you can appeal. Says I can't afford, so appeal filed, but it was dismissed for non-prosecution because you did not deposit that amount. Now that person goes to, then it was NAFTA there, and he says that look, I have not been given fair treatment. The justice delivery system, it is onerous. It says that I have to deposit this fee, and on that basis NAFTA assumes jurisdiction and holds it to be so. Now, how you can comment on the system, because that's a sovereign system, if there is a rule that you have to deposit, here also under our Income Tax Act, there is rule for in appeal that you have to deposit, if, you file, I think 20%.
Deposit
so
20%.
You have to deposit that amount. So the tribunal in that case held that the measure was, this governmental measure, it was susceptible to review under NAFTA, even though it stemmed from a private law litigation. And in that case, this is what I wanted to read, that we still have right to decide contrary to what American justice system has decided. Now, these are the cases which are raising disputes and which are making, and of course, white industry, there are quite a few other examples also, but I don't want to say that. So therefore, this debate is there and it will always be there. At the same time, states also, and like India, which you have also mentioned in your report, has to be little pragmatic. We want foreign direct investment, not that we don't want. So we have to give some solace or some comfort to the investors at the same time. We just can't say, and that is why I started and gave the example that where in international law, after this globalization, etc., not only convergence of laws is taking place, and here it comes as convergence of law when it comes to this in the form of international law. Because that is one which is uniform law, which is applicable. And not only that is taking place, but at the same time, as I said, sovereign authority to some extent is ceded, that the courts, the governments are acknowledging. When it comes to international disputes, when it comes to dispute with, where the other nationals of other countries are there, then we can't claim our sovereignty to that extent which we can claim on our own subjects. So I think all this has to be taken into consideration, and I again I mean congratulate you for this, and I feel to some extent the way cases are being done or decided by the arbitral tribunal, that also leaves much, I mean much leaves to be desired, and let us see whether this concept of coming with court etc. that fills the gap or not. Thank you.
We have 5 to 7 minutes to take questions. There are mics. There's one mic lying on the my left-hand side on the first table, and there's another one that Abhi is carrying. So please raise your hand in case you have any questions, and we'd be delighted to take. Gentleman there. Yeah, please. Please direct the question.
My name is Surinder Singh. I work as a carbon auditor, and I'm not exactly sure, but in the next 26 hours, there is the deadline to submit public comments on India's proposed CCTS scheme. There will be new carbon credit market in India as well as we have in Europe and United States as well. My question is, now we have this, or this is going to be the first experience of India to create a mechanism to trade carbon credits of international scale and as per the international norms. Where India's legal understanding is in terms of carbon credit market, policies, regulatory framework, or international environment laws, or do you think that could become another Vodafone and Keynes? Thank you.
Is your question directed to any specific individual?
My apologies. Anybody could go ahead with that, because I'm not exactly sure to which it should go to.
But it is not a case of, I mean, the subject which we are discussing. It doesn't relate to that. It's totally different aspect or different case. I mean, on environmental effect of many industries are set up, it may be related to the, in the sense when the foreign investment comes and something is, but then the question is in a totally different context. I don't know, it may generate a totally different kind of debate and different kind of discussion altogether.
But if I may just sort of quickly respond, I think if your concern is that would this also result into foreign investors suing India under investment treaties of the kind that happened because of retroactive taxation, I guess that's what you're asking in context of international investment law. The answer is no. I mean, even if they do, I don't think the arbitration tribunals would rule in their favor, because I don't think this kind of regulatory mechanism would breach any of the investment treaties.
Yeah, Aparna has a question here.
Vis-a-vis qua exit, which is basically allows investors to approach them rather than, because I was taught by Professor T.N. Srinivasan, and he always believed that the WTO dispute resolution had a birth defect. But vis-a-vis exit, which India has not ratified, is it also on both sides? Because there is also this perception internationally also with an IL, international relations, international law, belief that is it anything to do with the fact that how it is funded? Because they have also not been very transparent. I wouldn't completely say that it's unfair for countries now to realize who is actually in the administrative part of it or in the funding part of it. Do you think the hesitation is more towards India, the World Bank funding exit? And then the World Bank funding exit, it comes right from the Bretton Woods institutions. And then later on the investors, etc., having some more say, or the nations funding the World Bank having more say. So would that play out in the reluctance of a lot of whoever can be courageous enough?
I can make general remarks, which I'll make later, but let him, because
I'm not quite aware of the discussion, so let me not venture into something that I'm not.
See, I tell you, one thing which I feel is, you are right, it is naturally World Bank funded and It is created by the World Bank, which had a rather, in a way, I would say, I think way back in 1959 or so, the idea was, or the objective was noble. What has happened, and as I have seen, when I told you a few minutes ago that ICSID says that, look, this impression about us is wrong, because if you go by the statistics, we have decided more cases in favor of the republics than in favor of investors. But having said so, it is, I mean, as it is said, lies, damn lies, and statistics. So it is easy to manipulate statistics. The impression which is, and as I read it, of the third world and poor countries is that most of the awards have gone against them. So that, and that is not without any substance. There is some substance in this statement. So they feel that, look, when it comes to, and when a poor nation or third world countries, and there are many such awards against African countries and against South American countries, etc., also in many Asian countries as well. So therefore, you can say that, look, we have decided many cases in favor of, but those cases relate to those governments which are, those nations which are Western countries. So then you are only painting a half of the picture. So therefore, that may be one of the reasons. And whether it is due to World Bank or due to other reasons, I mean, that is where I said Prabhash can throw more light on that.
Yeah, if I can just sort of quickly respond to this. If you look at all the investment treaty arbitration mechanisms, I'll say that ICSID in fact is better than many others. In the sense that,
right. There you are
in
right.
the sense that it has developed a lot of transparency practices in the last several years. They have come up with several transparency instruments. Yeah. Also on the point of states losing, it's, in fact, it's not just developing countries, even developed countries have lost many.
No, not they have not lost. Yeah, not.
So if you look at the statistics and if you look at the top 10 respondent nations, in terms of being sued, you will find Canada, you will find Czechoslovakia, so you will find several developed countries there as well. But yeah, it's also true, as Justice Sikri mentioned, if you look at the overall statistic, and there's again a game there, if you look at the overall statistic, states have won more, investors have lost, states have won more and investors have obviously not won that much. But if you look at cases through the lens of jurisdiction and merits combined, then you will find that the scale sort of changes and it's investors winning more and not the states. So it's, it depends on how you sort of slice that statistic and then look at it.
Our research on publicly available data on tax-related BIPA claims was equally divided. Half of them were won by states and half of them were won by the investors.
But it's generally true, I think, if you look at the larger institutions which are forming a narrative in any sense, and that narrative has any objective. Let's say that today a technology, a view is to be formed on a particular issue. So the stakeholders who has got some interest in a particular narrative, there's the ways and means to, and funding is maybe one of those. So that's a reality of life today. And this is one of the segments what we look at in terms of the institution, the way they are operating. Most of the nations are struggling with this to find whether can be their foolproof mechanism to capture this. Different nations are taking different actions against these kind of fundings directly or indirectly in forming a narrative of any sort. But I think the way the world is operating, it is not going to change. The interference in one way or the other will remain.
Well, sorry, last question. Can we take that, Neetu?
Good evening. My question is to Justice Sikri. Sir, we say that now, India has bought peace with Vodafone, Ken, and we have, Bala in his individual capacity saying that, Ken and Vodafone is behind us. But whether international business community is able to buy this, that yes, Ken and Vodafone is behind us, are they in a position to really look at India in an objective way after this episode, or there is something more which India need to do, because we still have in 1+ theory, Vietnam emerging in some sectors, Thailand emerging in other sectors, Sri Lanka emerging. So what is that
That's
which
a very
India should be
interesting
doing?
question. Actually, I tell you, these decisions which the government has taken, change of law also went to that extent, and buying peace as far as these two cases are concerned, it has certainly positive effect. There is no doubt about it. But yes, to some extent, investor would still remain suspect that tomorrow there may not be any other measure which may be taken. Okay, today it is done, now it is undone after many years of legal battle, etc. These things are undone. Of course, it is a welcome step, but then what is the assurance that in future it would not do? It would not happen. But then that is not confined, or that is not limited to India only. I mean,
Correct.
this can happen anywhere and everywhere. But at the same time, maybe, yes, there are two representatives, again I say they are sitting. What else can be done in order to instill confidence in investor, that every country, because they want investment today, India is always thinking, okay, what is happening in international scenario and politics, etc., where, and today relationship between America and China, and some of the rather Western countries and China, where India has got the opportunity. At the same time, you are right, Taiwan and Vietnam, etc., are also in competition, and they are taking away a big chunk. So therefore, India has to compete with them. So this may be an issue at a larger level, that how to instill confidence and how to tell people that no, India is a good destination for investment, and it has to be a secured investment.
Thank you, sir. Many thanks.
Well, much as we would have liked to continue, we have to come to an end for this wonderful panel. It's been an honor to moderate this panel on behalf of Vidhi Center for Legal Policy and BMR Legal. I'd like to extend a heartful gratitude and thanks to our esteemed panel. Please join me. It's been an insightful discussion. Wanted to thank two of my researchers, or two of the only researchers, Akshara and Shreya. Thank you very much, and I hope we made it worthwhile for you. And also lastly, thank two of the organizations that supported this event, Tax Sutra and Society of Indian Law Firms. Dr. Lalit Bhasin expresses his regret. He was personally wanting to be here. And also Mr. Salve sent a kind of regret as well, that he's sorry he couldn't make it. So thank you very much all. Hope you enjoy the evening.